Okay, we're rolling.
Okay, good morning. This meeting is being conducted pursuant to New York State Open Meetings Law, Public Officers Law, Section 100, etc. For purposes of this meeting, I shall designate Julie Lee as the recording secretary. We have before us today consideration of the following proposed amendments to Title 53 of the Rules of the City of New York. First up would be the Board Rules for Board Rules Chapter 5. Second, the Board Rules Section 1-14, continuing from our February 28th open meeting. And then third, Board Rules Chapter 3, continued from our January 30th and March 12th open meetings. Okay, turning to Board Rules Chapter 5, which is new. We do have before us consideration of proposed amendments to Board Rules Chapter 5, which deal with the administration, implementation, and enforcement of the Legal Defense Trust Law recently passed by the City Council. Are there comments from the board or staff on the draft proposed amendments to Board Rules Chapter 5? Chad, I think you want to enlighten us on one point.
Yes. In response to questions, we reviewed a proposed section 5-02 titled Confidentiality. And the question being specifically what documents are required to be confidential, what documents is the board required to keep private. And in response to that question, we agree with sort of the point that was raised in the question, is that 5-02A is duplicative of a provision already existing in the administrative code. 5-02A only lists documents that are going to be public. However, documents gathered pursuant to this statute are presumptively public absent some other statutory reason. And so 5-02A should be removed as duplicative. 5-02B was written initially to provide notice to regulated parties of the sorts of documents that might be withheld, but in communications with the Campaign Finance Board, which is an agency that administers a similar law, we believe that it's more confusing and perhaps overbroad than initially intended. And we also would propose to remove that in its entirety. The public officers laws specify specific sorts of information that would be withheld in the production of any documents, and this wouldn't affect the sorts of information that's being disclosed publicly on the website that the board will be gathering as part of this regulatory regime.
So you're saying no, that provision will just be removed?
Right, that provision would be removed in its entirety, and the rest of the provisions would just be renumbered.
So just to restate that, so 5-02 confidentiality is being deleted, and basically everything else would follow with a new number. So 5-02 donations would now be 5-02 reporting and disclosure, 5-03, et cetera. And the statement of basis and purpose would be appropriately revised. Is there a statement of basis and purpose yet? I'm sorry.
There's a statement of basis and purpose, and that statement of basis and purpose would be revised to remove the paragraph titled Section 5-02 on the bottom of Exhibit 2, page 3.
Exhibit 2, page 3, right, exactly.
And that section would be removed.
Okay.
So I have one follow-up
Sure.
question. So with respect to, so 504, reporting and disclosure, on page, on exhibit 2, page 6, that would then become 503, I guess.
That's exactly right.
Do we need to add anything in that reporting and disclosure section saying that all the information will be public unless confidential under the law, or?
No, that point's already encapsulated in the administrative code, that absent sort of an independent statutory basis, the information is public.
In other words, the administrative code says that, in essence, this is just subject to the Freedom of Information law. And so there's not really any need for us to have anything specific here. We can rely on the Freedom of Information law and the exceptions that are built into that.
Right, so in the administrative code in 3-1103,
Right.
which is, it'll be LDT 5.
Right, exhibit 1, right?
Yeah, so it'll say, the Conflicts of Interest Board shall maintain and regularly update a list on its website of all legal defense trusts and all information disclosed to the board pursuant to this section. So the information is public, unless there's an independent reason that it would be withheld, either because it contains a certain information about people that should not be disclosed, or pursuant to the other exceptions in the public officers law.
Got it, and just adding that to the reporting regulation would just be redundant.
Exactly, and that was the problem with the initial section, is that it
Right.
duplicated the efforts in this in a way that's potentially confusing.
So the names and addresses of donors to these trusts will be public.
Yes, so the home addresses, there's some latitude in the Freedom of Information Law to withhold home addresses. There's also some, obviously you can withhold bank account numbers and some things like that. So we would have to, when we received a request for these sorts of documents, we would have to redact some of that sort of information. So that's going to be an administrative chore that we have to perform, but nevertheless, that is what the Freedom of Information Law
I
would
guess the
require.
conflicts of, the campaign finance law can be a guide for this too as well. Because
Right,
when
we-
you contribute, your information is made public. We should not treat that differently.
Right, the information is very similar. It's, I think, and we consulted with them about this specific question, and that has informed our thinking about this.
So the reporting of the donors that's like just information sort of typed into the website will look quite similar to the Campaign Finance Board's reporting system. The supporting documents, which might include additional information, the Campaign Finance Board advised us that they produce those documents if there's a FOIL request, but redacted. So we would follow a similar model.
I guess information on checks and then.
Exactly
That's exactly
right.
right.
Banking.
Right,
Right.
exactly right.
So it'd just be name and amount,
amount.
basically.
Name, address,
Name,
along with-
address, and amount,
Oh, sorry, yeah.
public, and then the bank information is confidential and private according.
That's exactly right. That's exactly right.
Would it be appropriate, I think, to put the statement of basis and purpose, some cross-reference the administrative code, just to say, well, we don't have a specific provision on confidentiality, because in the statement of basis, not in the rule itself, because it's going to be governed by the general freedom of information law. I mean, it's just trying to figure out how when we revise this, obviously, the description of section 502 goes, when we look at, I'm looking on page 2 of Exhibit 2, blah, 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 the item 2, identify the type of information. I'm just wondering whether, this is a question, it's not, is whether we want to just have somewhere in the statement that question, that the availability, the availability and or confidentiality of documents is generally will be governed by the Freedom of Information Law. But there's no specific provision here, we just want to stay silent on it.
I would recommend staying silent, because I
Okay.
think that administrative code speaks, and I
Okay.
think the rules should just say.
No, I was just saying in the statement of basis, not in
Yes.
the rule itself.
No, I
Okay.
understand, and I think
Okay.
the.
I'm
right,
fine
the-
with that.
Okay. I agree with that.
Okay, I'm fine with that. Anything else? Okay, so I call for a motion that the board adopt the recommended amendments to Board Rules Chapter 5 as the final rule, with the following modification: that the current Section 5-02 dealing with confidentiality be deleted, everything else be renumbered appropriately, and the statement of basis and purpose also be appropriately revised to reflect the deletion of the current Section 502. And otherwise, those being the only modifications. So again, a little garbled, so I call for a motion that the board adopt the recommended amendments subject to the change regarding 502.
So moved.
I do have that motion, do I have a second?
Second.
Okay, all in favor?
Aye.
Any opposed? Okay, the statement for adoption of proposed amendments with the modifications as discussed as the final rule has passed. Thank you, Chad. Okay. I've gotten my materials slightly out of order here. I don't really need that much. Okay, our next item is the proposed Board Rules Section 1-14. We have a first consideration of those proposed amendments. Are there, going through my own notes for a second, are there any comments from the board or staff on the draft of these proposed amendments to Board Rules 1-14? As I understand it, it's almost either entirely or almost entirely changing the tense from the subjunctive to the present as we move from proposed rules to actual rules.
Yes, that's right. The board received no comment
Right.
on this rule.
Okay?
And we debated it in full. so.
Yeah. Okay, further discussion? Then I call for a motion that the board adopt the recommended amendments to Board Rules 1-14 as the final rule.
So moved.
Second?
Second.
All in favor?
Aye.
Any opposed? The motion for adoption of the proposed amendments as presented as the final rule has passed. Carolyn, one quick question. What happens next with this rule?
So,
Chris, go ahead.
The rule, the rule now that it's adopted will be submitted to the city record for publication. Once that is published, which will be a week from today, or tomorrow, depending on when we get the final approval from the law department, that will go into effect 30 days from publication. And so we're looking at 5 weeks and change for when the
Roughly
rule-
mid-June.
Yes, when the rule will be in effect.
Okay, great, thank you. Third item up is Board Rules Chapter 3. We have before us consideration of proposed amendments to Board Rules Chapter 3. Again, these dealing with nonprofit organizations affiliated with city officials. We've had 2 of our own meetings on, 2 public meetings
Yes.
of ours before, and it was sent out for comment on a public hearing.
That's right.
I believe there were a handful of comments.
Yes, the board received 3 comments on the rule, 2 in writing and 1 orally at the public hearing, all by representatives of nonprofit organizations. One of the written comments was supportive of the changes. The other was generally supportive of the amendments, but contained additional proposals that would require amendments to the administrative code. And then the oral comment did not specifically address the proposed rule, but instead focused on the underlying administrative code provisions as well. So as a result, the proposed notice of adoption before the board today contains no changes to the text of the rule, and as with the other one, stylistic edits to the commentary to reflect that it would no longer be a proposed rule.
It changes the administrative code requiring the city council to act.
That's
Right,
correct,
okay, yeah.
yes.
Comments, discussion?
My only question
okay.
is, should we respond to Mr. Reimer and advise him of that, or? I mean, he took the time to write in the comments.
Yes, and
How do you typically handle that?
you know, we are, you know, as the comment, as his comment indicated, he is in conversation with us, and so, you know, I'm happy to communicate that to him.
But he knows we got the comment, and I
Exactly.
appreciate that he
Exactly.
commented.
Exactly.
Okay.
Yes.
Okay.
Okay, I call for a motion that the board adopt the recommended amendments to Board Board Rules Chapter 3, it's off morning today, as the final rule. Second?
Second.
All in favor?
Aye.
Opposed? Okay, the motion for adoption of proposed amendments as presented as the final rule has passed. I take it's the same process?
Yes.
They register and the 30 days thereafter?
Yes.
Okay. There being no further business for consideration pursuant to the open meetings law, this meeting is hereby adjourned.